Hi, my name is Michael Dora, and today I will be discussing two defamation cases. One will focus on public official and the other on a private citizen. Defamation is making false derogatory statements, whether it be private or public, about a person's business practices, character, financial status, morals, or reputation. Or defamation is slander, and public defamation is libel. The laws on defamation, for as long as it has been in existence in the United States, has had to walk a fine line between the right to freedom of speech and the right of a person to avoid defamation. Oral defamation is a slander, and published defamation is libel. In this case, the New York Times Company wrote an article describing the actions taken against civil rights protesters, which involved the police force of the city of Montgomery, Alabama. L.B. Sullivan, the Montgomery City Commissioner, filed a libel action against the newspapers and four black ministers, claiming that the allegations against the Montgomery City Police defamed him personally. Mr. Sullivan believes his reputation was damaged because the ad openly criticized the police department in the city of Montgomery, Alabama, for his treatment of the civil rights protesters. Sullivan was the commissioner at the time who supervised the police, so he took to offense to the New York Times article. By law, a plaintiff must show to prove libel by what was actually said against them, was false or with recklessness disregards to the truth. In this case, the United States Supreme Court decided that the right to publish a statement is protected under the First Amendment. The court also said in order to prove libel, a public official must show actual malice. In the next case, we'll be discussing a private citizen that was slandered in a public magazine. The parties involved are Gertz and Robert Welch. The practitioner, Gertz, is a private person who is an Illinois state attorney that was defamed in an article of the American Opinion magazine, which stated he had a criminal record and labeled him as a Leninist and a communist frontier. In this case, there was nothing done to confirm the allegation against Gertz. Instead, Welch magazine publisher apprehended an editorial introduction stating the author of the article had conducted intensive research into the case. I think these allegations against Gertz will not only affect his career and reputation as an Illinois attorney, but also as a citizen as well. To avoid this lawsuit, I would have made an attempt to reach out to Gertz for a one-on-one interview to discuss the case, instead of assuming the worst. The elements of defamation under Florida law claims the defamation must be published, a false statement, it must be about the plaintiff to the third party, and the falselessness of the statement has caused injury to the plaintiff. In conclusion, these were two different cases that discuss defamation. There is always a delicate balance between one's person's right to freedom of speech and another's right to protect their good name. It is often difficult to know which person's remarks are proper and which run afoul of defamation law. Defamation cases vary from state to state. These cases will help me to learn how to present and communicate information that does not defame public officials or private persons through third parties, radio, audio, and video. When it comes to the release to the public, I will be familiar with what is right and what is not right. Also, defamation is not actionable unless it is published. I also find it to be useful that businesses have just as much rights as an individual. All of this information will be remembered and used in my practice as a public relations specialist. I would like to say thank you, and I hope this information will be of some help to you.